Hello, and welcome to the Sexual Harassment Prevention Training. This course was developed by the Illinois Home Care and Hospice Council in July 2020 to meet requirements of Public Act 100-762. This law requires sexual harassment prevention training for all persons in Illinois who hold a professional license issued by the Division of Professional Regulation for professionals that require continuing education to renew. The law requires licensees to complete a 1-hour CE course in sexual harassment prevention training and is effective for all renewals on or after January 1st of 2020. This CE requirement is included in the number of hours already required under the individual acts and rules and does not increase the number of hours required to renew your license. I'm Liz Vogt, and I will be presenting today's webinar. I'm the Director of Government and Regulatory Affairs for the Illinois Home Care and Hospice Council. I have no conflicts of interest with regard to today's training. Today's learning objectives. The first, define sexual harassment, including its forms and types. The second, identify how to respond if you experience or witness unwelcome sexual harassment. The third, identify how to report sexual harassment within your place of employment and to outside entities. And the fourth, understanding your protections as a whistleblower. So why are we here today? The Me Too movement was founded in 2006 to help survivors of sexual violence, particularly Black women and girls and other women of color from low-wealth communities, find pathways to healing. The movement gained significant momentum following the exposure of the widespread sexual abuse allegations against Harvey Weinstein in early October 2017. This is when the Me Too movement began to spread virally as a hashtag on social media by women who had experienced sexual harassment or sexual assault. The Me Too movement has empowered individuals to report sexual harassment and sexual assault and expose their harassers through various industries, including entertainment and government. Throughout late 2017 and 2018, legislators, staff, and lobbyists in Illinois came forward to report allegations of sexual harassment in Illinois government, sharing both general stories of past experiences and making very public allegations against specific individuals. This led to creation of the Senate Task Force on Sexual Discrimination and Harassment Awareness and the House Sexual Discrimination and Harassment Task Force. In November 2017, the Illinois Senate unanimously adopted Senate Resolution 1076, sponsored by Senator Melinda Bush and co-sponsored by 2/3 of the Senate. This resolution created the Senate Task Force on Sexual Discrimination and Harassment Awareness and Prevention. At this same time, the Illinois House of Representatives passed House Resolution 687. This created the House Sexual Discrimination and Harassment Task Force. These task forces were created in direct response to the nationwide Me Too movement and to an open letter signed by more than 300 Illinois legislators, lobbyists, staff, and policymakers, acknowledging and condemning a pervasive culture of sexual harassment in Illinois politics and government. The resolutions outline the harm caused by sexual harassment and discrimination in both the public and private sectors, and recognize that Illinois has not historically provided victims of harassment with adequate recourse. The Illinois General Assembly also passed the Workplace Transparency Act, Public Act 101-0221. This law was signed by the governor in August 2019. The legislation takes a number of steps recommended by both the House and the Senate task forces, including the following: restricting non-disclosure and non-disparagement language in employment agreements, separation agreements, and settlement agreements, restricting an employer's ability to require mandatory arbitration of sexual harassment or other discrimination claims, requiring annual sexual harassment training provided by employers, and directing employers to report settlements and adverse judgments to the Illinois Department of Human Rights. Today's training is required by Public Act 101-0221, sponsored by Representative Mike McAuliffe and Senator Melinda Bush, and signed by the governor in August of 2018. As you can see, this one-page piece of legislation requires 1 hour of continuing education in sexual harassment prevention as part of licenses renewed on and after January 1st of 2020. This legislation also gave the Illinois Department of Financial and Professional Regulation the authority to adopt rules to implement the law. An IDFPR did adopt rules in May of 2019 to implement the law. 68 Illinois Administrative Code, Part 1130.400, requires the 1 hour sexual harassment prevention training course to include the following topics, which coincide with our learning objectives today. What is sexual harassment, including its forms and types? What should one do if one experiences or witnesses unwelcome sexual contact? Reporting sexual harassment within one's place of employment and to outside entities such as the Illinois Department of Human Rights, and whistleblower protections. It's important to note that there were 2 laws passed by the Illinois General Assembly, both requiring sexual harassment prevention training. One is a requirement of all employers to offer sexual harassment prevention training to their employees. The Illinois Department of Human Rights has provided a model training that employers can use to train their employees. This must be done annually. The other law requires all licensed professionals in Illinois who are licensed by the Illinois Department of Financial and Professional Regulation to take a 1 hour sexual harassment prevention training as part of their continuing education credits to renew their licenses. Note that in some instances, you may be required to take the annual sexual harassment training from your employer in addition to the continuing education sexual harassment training required for your license. Today's training meets the state requirements for the license renewal CEs. So let's start by talking about what exactly is sexual harassment. Sexual harassment means any unwelcome sexual advances or requests for sexual favors, or any conduct of a sexual nature when submission to such conduct is made either explicitly or implicitly a term or condition of an individual's employment. Submission to or rejection of such conduct by an individual is used as the basis for employment decisions affecting the individual, or such conduct has the purpose or effect of substantially interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. Note, in this situation, the working environment is not limited to a physical location an employee is assigned to perform his or her duties, and does not require an employment relationship. So this means that sexual harassment can occur outside of the brick and mortar office setting, and it can also occur when it involves an employee of your organization and a non-employee of your organization, like a contractor, a patient, a vendor, or other individual who may be working in close contact with your staff. Harassment can be sexual harassment or unwelcome sexual advances, requests for sexual favors, and other verbal or physical harassment of a sexual nature. Harassment is the umbrella term, and sexual harassment falls within that harassment umbrella. It's important to note that both the victim and the harasser can either be a man or a woman, and the victim and the harasser can be the same sex. The harasser can be the victim's supervisor, a supervisor in another area, a coworker, or someone who is not even an employee of the employer, like a client or customer. Although the law does not prohibit simple teasing, offhand comments, or isolated incidents that are not very serious, this is important to note that harassment is illegal when it is so frequent or severe that it creates a hostile or offensive work environment, or when it results in an adverse employment decision, such as the victim being fired or demoted. The courts have defined two separate types of behavior that qualify as unlawful sexual harassment. The first type of sexual harassment is called quid pro quo, which means this for that. In quid pro quo sexual harassment, an employer or supervisor makes submission to unwanted sexual advances or conduct an implicit or explicit condition of employment or employment benefits, or uses such submission or refusal as a basis for making employment decisions concerning the victim. To qualify as quid pro quo sexual harassment, the harasser must be in a position of power over the victim and have the authority to grant or deny the victim employment or employment benefits. One instance may be enough to constitute sexual harassment, even if a threat is not acted upon. Conduct that falls into this category of quid pro quo sexual harassment typically occurs when an employee or job applicant suffers an adverse employment action. Things like termination, demotion, a pay cut, a rejection of employment for refusal to engage in unwanted sexual activity. For example, a supervisor that threatens to fire an employee if he or she does not go on a date with or otherwise engage in certain sexual acts with the supervisor has likely engaged in quid pro quo sexual harassment. The second type of sexual harassment the courts have defined is called hostile work environment. Hostile work environment sexual harassment occurs when an employee is subjected to sufficiently severe or pervasive sexually offensive speech or conduct that it creates an intimidating, hostile, or offensive working environment, which affects the victim's job performance. Unlike quid pro quo sexual harassment, the harasser might be a supervisor, but could be a coworker or even a non-employee. Examples of conduct that may create a hostile working environment includes things like verbal behavior, like sexual innuendos, suggestive comments, insults, sexual language, and jokes about sex, anatomy, gender, or gender-specific traits, sexual propositions, threats, repeated requests for dates, or statements about other employees, even outside of their presence. Nonverbal behaviors, things like suggestive or insulting sounds like whistling as someone walks by, leering, obscene gestures, sexually suggestive bodily gestures, catcalls, smacking or kissing noises. Visual behavior, posters, signs, drawings, pictures, or calendars of a sexual nature, viewing pornographic material, or websites of a sexual nature. Physical behavior, things like touching, unwelcome hugging or kissing, pinching, brushing against someone's body, any coerced sexual act, or actual sexual assault. Digital or electronic behavior, sexting, which is electronically sending messages with a sexual content, including pictures and/or videos, the use of sexually explicit language, harassment, cyberstalking, and threats via all forms of electronic communication, including emails, texts, and social network websites. Whether the conduct is severe or pervasive enough to create a hostile work environment is very fact-specific and is determined on a case-by-case basis by the courts and administrative agencies. It usually takes more than one incident to create a hostile work environment. However, the more severe the conduct is, the less pervasive it needs to be. A singular instance of conduct that is severe may rise to the level of creating a hostile work environment. Ultimately, to be unlawful, the conduct must create a work environment that would be intimidating, hostile, or offensive to not only the victim, but also to any reasonable person. So as we just discussed, it's important to note that sexual harassment can be in any of the following forms: verbal, visual, physical, written, or typed. Anyone can be a harasser, just as anyone can be the target of sexual harassment, regardless of their sex, their sexual preference, their age, or professional position. So you might be wondering what motivates people to sexually harass others. Usually, it's a way to express dominance, power, or superiority over colleagues and coworkers. It can be used as a bullying tactic. It can be used to organizationally or socially control someone. Someone might have a desire to protect their own turf, or even be attempting to seek approval from their peers. So how prevalent is sexual harassment in the workplace? The Equal Opportunity Employment Commission's 2016 Select Task Force on the Study of Harassment in the Workplace found that between 25% and 85% of women report having experienced sexual harassment in the workplace. That number jumps to 60% when you ask whether women have heard sexist or crude language while at work. Note that this study was conducted prior to the rise of the Me Too movement in 2017. A poll by NBC and the Wall Street Journal conducted in October 2017 indicated that 48% of currently employed women in the United States report that they have personally experienced an unwelcome sexual advance or verbal or physical harassment while at work. It's also important to note that these figures are based on self-reported surveys of women. Individuals, both male and female, that have actually experienced sexual harassment, the rate might be much higher because they may choose not to report or respond to these surveys or polls. So how prevalent is sexual harassment in the healthcare workplace? In a 2018 report by Frischlang and Faria, 27.9% of nurses globally report experiencing sexual harassment. The occurrence is higher in countries like Australia, Canada, England, and the United States, which 38.7% of nurses reported experiencing sexual harassment here in the United States. In a 2020 report by Vargas et al., 82% of women in an academic medical setting reported at least one incident of sexual harassment in the past year. In its 2018 report on sexual harassment of nurses, nurse practitioners, and physician assistants, Medscape reported that 11% of nurses had experienced some form of sexual harassment in the last 3 years, and 14% had witnessed sexual abuse, harassment, or misconduct. According to the EEOC data, at least 3,085 employees at general medicine and surgical hospitals filed claims of sexual harassment between 1995 and 2016, including 314 in the home health setting. According to a recent Sentinel alert issued by the Joint Commission on Physical and Verbal Violence, including sexual harassment against healthcare workers, 75% of workplace assaults reported annually occurred in healthcare and social service settings. And workers in healthcare are 4 times more likely to be victimized than workers in private industry. So now we're going to run through a couple of scenarios to reinforce your understanding of sexual harassment and the types. So the first scenario, Jake is a clinical supervisor for Kate, the administrator of ABC Home Health Care. Kate has asked Jake to stay late for the past 2 weeks to work on quality improvement projects with her. Jake and Kate are friendly and sometimes even flirt a little bit. One evening, Kate tries to kiss Jake, but Jake turns away and explains that he does not believe it would be appropriate. The next day, Kate tells Jake about a job opening for a field nurse position and explains that she believes it would be a wise move for him to apply for the position so he would not be in the office on a daily basis. Does this constitute sexual harassment, and if so, which type? The answer is yes, quid pro quo sexual harassment. Jake's determination to turn down Kate's request resulted in Kate suggesting that he take a field nurse position. This would constitute quid pro quo sexual harassment. The second scenario. Jenny has worked for XYZ Home Care for a few months as a field nurse. She recently attended a happy hour after work with some of her coworkers, Alyssa and Megan. After a few drinks, Jenny revealed something personal to the group. At the staff in-service training the next day, Jenny walked in to find everyone whispering and laughing. Alyssa and Megan told Jenny that it was all in good fun and they didn't know that her personal tidbit was a secret. Now the whole agency has an embarrassing nickname for Jenny. Her work performance has suffered significantly and she has used all of her PTO. Does this constitute sexual harassment, and if so, which type? Yes, this could potentially constitute a hostile work environment sexual harassment because the incidents and jokes of a sexual nature are pervasive enough to affect her job duties and her performance at work. The third scenario, Mary Kate is a biller for We Care Home Care. She and her boss, Bill, are friends. Every Monday, Bill comes into the office and chats with Mary Kate at her cubicle for about 30 minutes. Bill has a very active social life and always tells Mary Kate about his sexual encounters from the weekend. Does this constitute sexual harassment, and if so, which type? The answer is yes, that this could constitute hostile work environment sexual harassment. This is an ongoing situation where Bill comes in every single Monday and talks for about 30 minutes about stories of a sexual nature. It's ongoing and it's persistent. And if it can be shown that it is negatively impacting work performance, there could be a case for hostile work environment. The fourth scenario. Pete is a physical therapist and has been providing therapy to Maureen in her home for the last 45 days. Pete has repeatedly gone to his clinical supervisor to report that during every visit, Maureen makes inappropriate comments and tries to touch Pete in private places. Pete's supervisor laughs off Pete's reports and tells him not to be so sensitive. Does this constitute sexual harassment, and if so, which type? Again, yes, this could constitute hostile work environment sexual harassment. This has been an ongoing issue. It's persistent, it's pervasive. Pete's tried to report it to his clinical supervisor with no action taken. So yes, a case could be made for hostile work environment, especially if Pete's job performance and work life has suffered. And our last scenario. Louise has worked for XYZ Home Health for over 5 years and has never received a raise or promotion. She works hard and has never had any disciplinary action. She's even been awarded Employee of the Month 3 times during her tenure. Louise scheduled a meeting with her administrator, Bob, to request a pay raise. During that meeting, Bob invited Louise to dinner and implied that he would gladly give her a raise immediately if she accepted. Does this constitute sexual harassment, and if so, which type? The answer is yes. This could constitute quid pro quo sexual harassment, or this for that. The administrator is offering his employee a raise if she goes on a dinner date with him. So how should you respond if you are the victim of or a witness to sexual harassment? If you're the victim or a witness to sexual harassment, you're likely going to feel many different emotions: shocked, angry, embarrassed, anxious, scared, sad. First and foremost, you need to tell the harasser to stop. Be very specific and clear that the behavior is making you uncomfortable and the behavior is unwelcome. Do not be apologetic when you tell the harasser to stop the behavior. You're also going to want to document everything about the incident or incidents: the date, the time, and the location of the harassment, exactly what happened, what was said and who said what, and who witnessed the behavior, if anyone. You're going to want to keep copies of any relevant evidence like emails, texts, photographs, or any other documents that can prove the case of harassment. This information will be very important as you try to make the case and your employer investigates the incident. You're going to want to keep copies of your work records, including copies of your performance evaluations and any memos or letters documenting the quality of your work. Your harasser may try to defend him or herself by attacking your job performance. This is especially important in cases of hostile work environment, where you need to show that the behavior or the harassment has had a negative impact on your job performance and your work life. You may also want to think about keeping all of these documents and records in a file away from your office, potentially at your home, just in case someone were to find them in your desk, on your computer, or try to interfere in any way with your documentation. You may want to tell a trusted friend, a family member, or even another coworker. They can provide you with support and also provide corroborating statements when your employer investigates your complaint. You're also going to want to think about your goal or ideal outcome from the situation. Maybe it's simply for the harassment to stop. Maybe you want the harasser removed from his or her position at your agency. Maybe you want to be moved into a different part of your agency. Maybe you are seeking compensation for lost earnings and emotional distress. Whatever the case may be, it's important to determine what your ideal outcome of the situation would be. You're also going to want to review your company policy. Every company should have a sexual harassment policy on the books. Make sure you understand what the policy is, what employees are expected to do if they experience or witness harassment, and how to go about reporting it internally. If you do decide to report the incident, you should follow the guidelines contained in your company's policy very carefully. You're going to want to familiarize yourself with the statute of limitations. Under both state and federal law, complaints to government entities outside of your employer must be filed within 300 days of the incident. You may also want to consider talking to a lawyer or an attorney. Legal actions may not be the perfect solution to sexual harassment. Finding an attorney could be difficult, especially if you need to hire the attorney on a contingency fee basis, meaning that the attorney only gets paid if you win the case and recover money from your employer. Lawsuits are time-consuming, expensive, and often emotionally difficult. But if you're unable to obtain relief by confronting the harasser or pursuing internal procedures within your agency, taking legal action may be your best recourse. You're also going to want to consider what to expect after you report the harassment. Make sure that you have an understanding of how you're going to feel mentally, physically, and emotionally after you report, and how other people, including your coworkers, friends, and family, will react to your report. This is especially important important as you continue on in your role at work and, reaching out to staff in your office or other friends, family, to get that support that you need. You're going to want to think about what action you're going to take. Obviously, if the sexual harassment is criminal in nature, you should seriously consider reporting the incident to law enforcement immediately. If you choose to report the harassment to your supervisor or another superior, again, you need to make sure that you're following the protocols and procedures in your company's policy very carefully. And if you choose to report to an outside government entity, you should follow the steps to file a charge very carefully. Some agencies and companies have different staff members designated within their organization to address complaints of sexual harassment. Some policies may direct you to a supervisor, to another superior within your organization, to the HR department, and some organizations have even designated a sexual harassment staff member to deal with complaints. Again, you're going to want to document everything. We discussed earlier documenting everything about the incident. You're also going to want to document everything that happens, everything that's said after you report the incident of sexual harassment. This is very important if you're trying to show or prove that you've been retaliated against after you've reported. So how do I report sexual harassment? What should I expect of my employer? Well, employers should be taking preventative actions and remedial actions to address sexual harassment in the workplace. In terms of preventative actions, employers should affirmatively raise the subject with all of their employees, express strong disapproval of sexual harassment in the workplace, develop appropriate sanctions for those found to have engaged in sexual harassment, inform all of the employees of their right to raise and how to raise the issue of sexual harassment in the workplace, and also develop methods to sensitize all concerned parties. This is where training comes into play. In terms of remedial actions, employers should investigate promptly and thoroughly complaints of sexual harassment. Employers should take immediate and appropriate corrective action by doing whatever is necessary to end the harassment. Employers should also make the victim whole by restoring any lost employment benefits or opportunities within the organization. An employer should also make sure that the misconduct does not occur again. Disciplinary action against the offending supervisor or employee, ranging from reprimand to discharge, may be necessary. Generally, the employer wants to match the corrective action to the severity of the conduct. The employer should also make follow-up inquiries with the victim to ensure that the harassment has not resumed and that the victim has not suffered any retaliation as a result of reporting the sexual harassment. So after you report an incident to your employer, you should expect your employer to initiate an investigation. As part of that investigation, they will interview the victim, they'll interview the harasser, the alleged harasser, they'll interview any witnesses to the incident or incidents, they'll attempt to obtain any corroborative evidence. So this is where all of your documentation can be provided. And then they will take appropriate action if necessary based on the results of the investigation. As part of the investigation, if you're the victim of or a witness to sexual harassment and you've chosen to report the sexual harassment, you should be prepared to answer the following questions. Where did the behavior or incident occur? Who was involved? Were there any witnesses to this behavior or incident? Have you talked to anybody else about what's happened so that they could provide corroborating evidence? Has this happened before, or is this the first time? Is it an ongoing and pervasive issue or a one-time isolated incident? And was the person told that the behavior was unwelcome and to stop? If you choose to report the sexual harassment to entities outside of your employer, you can do so to entities at the state level and at the federal level. In Illinois, the Human Rights Act prohibits sexual harassment in the context of employment and education. The Illinois Department of Human Rights is charged with investigating claims of sexual harassment, while the Illinois Human Rights Commission is the administrative adjudicatory body that resolves cases involving sexual harassment. It's very important to note that you must file a charge of sexual harassment with the Illinois Department of Human Rights within 300 days from the date the harassment took place. To report sexual harassment to the Illinois Department of Human Rights, you can call the Sexual Harassment and Discrimination Helpline at 1-877-236-7703, or you can visit the department at one of its offices in Chicago or Springfield. The addresses are listed on the slide. If you choose to report to an outside entity at the federal level, the Equal Employment Opportunity Office, or EEOC, is charged with enforcing the federal equivalent of the Illinois Human Rights Act, which is Title VII of the Civil Rights Act of 1964. The EEOC is responsible for receiving, investigating, and pursuing appropriate legal recourse in cases of sexual harassment under federal law. If you're not sure who to report it to, either the state level, the Illinois Department of Human Rights, or at the federal level, the EEOC, it's important to note that in some cases, both state and federal law apply. The state and federal agencies have a work sharing agreement that outlines how each agency will handle the intake of claims in cases with dual federal and state jurisdiction. Complainants may then choose a forum in which to pursue their claims. So if you believe you've been discriminated against at work because of your race, color, religion, sex, national origin, age, or disability, you can file a charge with the EEOC. You can do so by visiting publicportal.eeoc.gov. Submitting a charge is a signed statement asserting that an employer, a union, or a labor organization engaged in employment discrimination, and it requests the EEOC to take remedial action. Again, it's important to note that you have 300 calendar days from the date the discrimination took place to file a charge with the EEOC. It's also important to note that filing a charge of discrimination with the EEOC is a required step before you can file a job discrimination lawsuit against your employer. Will I be protected from retaliation for blowing the whistle? In Illinois, yes, whistleblowers are granted special protections for reporting incidents of sexual harassment. Passed in 2004, the Illinois Whistleblower Act prevents employers from retaliating or threatening to retaliate against employees for disclosing certain information in certain instances. This means that certain policies are prohibited. Employers cannot adopt or enforce any rules, regulations, or policies that would prevent employees from disclosing information to a government or law enforcement agency if the employee has reasonable cause to believe that the information discloses a violation of state or federal law, rule, or regulation. Retaliation for certain disclosures is prohibited. This means that an employer cannot retaliate against an employee who discloses information in a court, in an administrative hearing, before a legislative commission or committee, to a government agency or a law enforcement agency, where that employee has a reasonable cause to believe that the information discloses a violation of state or federal law, rule, or regulation. Retaliation for certain refusals is prohibited. This means that employers are prohibited from retaliating against an employee who refuses to participate in an activity that would result in breaking a state or federal law, rule, or regulation. Further, threatening retaliation is prohibited. Civil penalties and damages for violations can be assessed under the Whistleblower Act in Illinois. Violations of the Act constitute a Class A misdemeanor. If an employer is found to have retaliated, the employee then has right to bring a civil lawsuit against the employer for things like reinstatement to the position with the same seniority status that the employee would have had absent the retaliation, for things like back pay with interest, and for things like compensation for any damages sustained as a result of the violation. Things like litigation costs, expert witness fees, and even reasonable attorney's fees. So we're going to review what constitutes retaliation. Retaliation is any act of revenge or backlash against someone who has reported sexual harassment. This includes any negative act as a result of them issuing and reporting the complaint. Examples of retaliation include things like mistreatment, insults, mockery, bullying, gossip, threats, giving poor performance evaluations, denying the employee raises or promotions, sabotaging their work, reassigning them to a different area, a different position, a different project, forcing them to take an unpaid leave of absence, firing them, and even cases of assault. So now we're going to talk briefly about workplace culture and best practices. All employees play a part in creating and maintaining a positive workplace culture. This means that each and every one of the employees within an organization is responsible for upholding the responsibilities, the policies, the procedures, and a positive culture within their organization. The primary goal of every employer should be the prevention of sexual harassment. It's much preferable to prevent sexual harassment in the workplace by taking preventative steps that we discussed earlier. Things like talking about sexual harassment and how it's not tolerated, conducting frequent trainings with employees to identify sexual harassment, making sure your policies and procedures are up to date, making sure that employees know how to address and report sexual harassment in the workplace if it were to occur. Again, every workplace should establish and then regularly review and update their sexual harassment policies. So you shouldn't just develop a policy, put it in a binder or on your SharePoint site, and then leave it there for eternity. It's important that this topic be revisited on a frequent basis to make sure that your policies and procedures are up to date and that your staff are educated on those procedures. Every workplace should also provide regular training on sexual harassment, not just a one-time training. So we shouldn't need the Illinois General Assembly to force us to train our employees. This should be a part of our workplace culture, that sexual harassment is wrong and cannot be tolerated. It could be brought up, in short order at staff meetings or other in-services, and not just a one-time training that you take and then forget. It's important to note that with regard to positive culture within our organization, we should all be held accountable and we cannot tolerate inappropriate behavior in the workplace. This means we need to be a good coworker, we need to be a good person, and we need to stand up for what is right and condemn what is wrong. We also need to focus on prevention rather than remediation and addressing incidents of sexual harassment after the fact. We should be proactive rather than reactive. So now we're going to do a quick review and give you a few key takeaway points. Obviously, sexual harassment is wrong and we cannot tolerate it in our workplaces and in our everyday life. We should all establish a positive workplace culture focused on prevention of harassment. Sexual harassment comes in various forms and types, including quid pro quo or this for that, and hostile work environment sexual harassment. Anyone can be a harasser, just as anyone can be a victim. If you are the victim or you witness sexual harassment, you should take certain steps to remedy the situation. Things like filing a complaint with your employer and even potentially involving outside government entities. And finally, a reminder that any retaliation against employees for reporting sexual harassment is illegal in Illinois, and there are protections afforded to whistleblowers in Illinois. This concludes today's training session. Thank you for your time and attention. Please be sure to click Submit on the pop-up box following this slide so you can submit your answers to the questions that were asked during this training and to complete the video. Next, you're going to want to visit this course's homepage to complete the quiz, the evaluation, and then access your CE certificate.